And I welcome members to the 21st meeting in 2013 of the Delegated Powers and Law Reform Committee and ask members to switch off any mobile phones. Agenda item 1 is a decision on taking business in private. It's proposed the committee takes item 5 in private. This is consideration of a draft report on the delegated powers contained in the Regulatory Reform Scotland Bill at stage 1. Do members agree to take item 5 in private, please? We do, thank you. Agenda item 2 is instruments subject to negative procedure. No points have been raised by our legal advisers on the sale of alcohol to children and young persons, Scotland Amendment Regulations 2013, SSI 2013-199. Is the committee content with that instrument, please? Agenda item 3, instruments not subject to any parliamentary procedure. And again, no points have been raised by our legal advisers on the Act of a Journal, Criminal Procedure Rules Amendment Number 2, Sexual Offences Act 2003, Notification Requirements 2013, SSI 2013-196, nor on the Act of a Journal, Criminal Procedure Rules Amendment Number 3, Miscellaneous 2013, SSI 2013-198. Is the committee content with these instruments, please? Thank you. Which brings us to agenda item 4, which is the Tribunals Scotland Bill. The purpose of this item is for the committee to consider the delegated powers in the Tribunals Scotland Bill at stage 1. In considering the bill, the committee is invited to agree the questions it wishes to raise with the Scottish Government on the delegated powers in the bill. It is suggested these questions are raised in written correspondence. The responses received will help to inform a draft report on the bill, which the committee would expect to consider in September. It's suggested that the same questions could be put to the Scottish Government in relation to the following sections. Section 19.1, which provides that the first-tier tribunal is to be organised into a number of chambers having regard to the subject matters falling within the tribunal's jurisdiction and any other factors relevant to the exercise of the tribunal's functions. Section 19.2 confers power on the Scottish ministers by regulations to make provision in connection with this structure. Section 22.1, which provides that the upper tier is to be organised into a number of divisions having regard to the subject matters falling within the tribunal's jurisdiction and any other factors relevant to the exercise of the tribunal's functions. Section 22.2 confers power on the Scottish ministers to make provision in connection with this structure. In relation to sections 19.2 and 22.2, therefore, does the committee agree to ask the Scottish Government in what circumstances it is considered that it may be more appropriate for the Lord President or tribunal rules rather than Scottish ministers to determine matters relating to the structure of and allocation of functions within the first-tier tribunal or the upper tribunal, as the case may be, and why it is considered appropriate that provision made by ministers regarding the structure of and allocation of functions within the tribunal will require consultation and attract a higher level of parliamentary scrutiny, but that such provision may be made by the Lord President or by the tribunal rules under delegated authority, with no consultation or parliamentary procedure required, and what limits, if any, are likely to be placed on the delegation of that authority. Okay. Thank you. It's suggested that the same questions could be put to the Scottish Government in relation to the following sections. Section 35.1 provides for Scottish ministers by regulations to make provision for determining the composition of the first-tier tribunal when convened to decide a case falling within its jurisdiction. Section 37.1 confers powers on the Scottish ministers by regulations to make provision for determining the composition of the upper tribunal when convened to decide a case falling within its jurisdiction. In relation to sections 35.1 and 37.1, therefore, does the committee to agree to ask the Scottish Government in which circumstances it is considered appropriate that it may be more appropriate for the President of Tribunals or tribunal rules rather than Scottish ministers to determine the composition of the first-tier tribunal or the upper tribunal, as the case may be, and why it is considered appropriate that provision made by ministers regarding the composition of the tribunal should attract the affirmative procedure, but that such provision made by the President of Tribunals or by tribunal rules under delegated authority, with the result that no or limited scrutiny will be required, and what limits, if any, are likely to be placed on the delegation of that authority.
Agreed.
The power of section 38.3b relates to the provisions in the bill which will allow the first-tier and upper tribunals to review their own decisions without the need for a full onward appeal. a decision may be reviewed at the tribunal's own instance or, with the tribunal's agreement, at the request of a party in the case. Does the committee agree to ask the Scottish Government why it is considered that the power in section 38(3)(b to exclude by tribunal rules decisions of the Scottish tribunals from review or otherwise to restrict the availability of review of those decisions is considered to be a power relating to technical procedural matters, and why it is considered appropriate that exclusions may be contained in tribunal rules which are not subject to parliamentary procedure other than laying, when the principal exclusions are contained on the face of the bill and may be modified or added to by regulations made by the Scottish Ministers.
Agree.
Thank you. Section 48(1) provides that a decision of the Scottish tribunals against which there is a right of appeal under another enactment is an excluded decision to which the provisions for review and appeal set out in this part of the bill do not apply. Section 48(2) conveys a power on the Scottish Ministers by regulations to make exemptions to that general rule. Does the committee agree to ask the Scottish Government where the transfer in power under section 27(2) is exercised in a way which leaves any existing appeal rights in relation to the listed tribunal intact, so that section 48(1) applies to exclude decisions subject to those appeal rights from review or appeal under sections 38, 41, 43 of the bill? Does the power under section 48(2) enable provision to be made to the effect that those decisions are in fact to be subject to review or appeal under sections 38, 41 or 43?
Agree.
If so, can the Scottish Government explain why it is considered appropriate that the power under section 48(2) should be subject to negative procedure when section 27(2) power is subject to affirmative procedure?
Agree.
And can the Scottish Government explain whether, in the circumstances described, it is intended that there will be a choice of appeal rights as between appeal under the existing legislation and appeal under the bill? If not, which power will be used to specify which of the appeal rights is to apply?
Agree.
Section 56(1) provides that the first tier tribunal and the upper tribunal may be convened in any place in Scotland to hear cases or for any other purpose relating to their function. Section 56(2) states this is subject to any provision made by tribunal rules as to the question of where in Scotland the Scottish tribunals are to be convened. Does the committee agree to seek clarification in relation to section 56(2) as to why it has been considered appropriate that the Court of Session may, in the tribunal rules, provide as to the question of where in Scotland the Scottish tribunals are to be convened, and why it is appropriate that this power is not subject to parliamentary procedure?
Agree.
Section 68 enables the President of Tribunals to issue directions as to the practice and procedure to be followed in proceedings of the Scottish tribunals. These may include instructions or guidance on the application or interpretation of the law and the manner of making a decision in a case. Does the committee agree to ask the Scottish Government for clarification as to why Section 68 does not provide that the practice directions which may be issued under that section require to be published, and what the intentions are in relation to publication?
Agree.
Section 74(1) confers a power on Scottish Ministers by regulations to make such supplemental, incidental, consequential, transitional, transitory or saving provision as they consider necessary or expedient for the purposes of or in connection with the bill. The section provides that the power to make ancillary regulations can be exercised for the purposes of or in connection with the bill provisions. This differs from, for example, the ancillary powers provision in section 45 of the Regulatory Reform Scotland Bill, which requires the ancillary powers to be for the purposes of, in consequence of, or for giving full effect to any provisions of the bill. It seems that ancillary power matters might have a connection with the bill provisions, but not be either in consequence of or giving full effect to them. Section 74 appears, therefore, to provide a broader scope to the ancillary powers than is more usual. Does the committee agree to ask the Scottish Government why, therefore, it is a different formulation of the ancillary powers which is proposed for this bill?
Agree.
Paragraph...
Sorry, Chair, I'm just wondering the wording of that last sentence. When we're asking why is there a difference.
Yep.
I'm not sure if that's how we should be putting the question, unless legal advisors are comfortable with that.
Well, can I suggest that I think our advice is that the second formulation is the usual one or the more usual one.
Right.
And as there's no explanation at all as to why they've used the other one, I think probably why is the question that we're asking at this stage. Hopefully they'll provide enough answer in there that we won't be asking them why they think the formulation they've come up with is a good one, because they'll tell us.
Okay.
Are we agreed? Yeah, thank you. Paragraph 14 of Schedule 7 provides for a power of ministers to determine the terms of the conditions on which a member of the Scottish tribunals holds that position, except as provided for in the bill. Paragraph 2 of Schedule 2 confers power by regulations to provide for other terms and conditions of appointment of members of the Scottish tribunals other than the judicial members, apart from the terms specified in Schedule 7. Does the committee agree to ask the Scottish Government, why is this power necessary or appropriate, and why is it appropriate to be exercised in the form of a determination and not subject to parliamentary procedure or a requirement for publication?
Agreed.
Thank you very much indeed. That concludes item 4, and I move this meeting into private.